It was a unanimous decree from the top bench. A resident of New Brunswick importing too many cases of cheap beer from Quebec was busted for exceeding provincial limits in 2012, and the charge was upheld today after 6 years of legal wrangling. Gerald Comeau was attempting to set a precedent which would knock down the right to limit certain controlled goods from entering the province. The so-called Free the Beer campaign fell flat at the Supreme Court this morning. Let's bring in our legal translator on major court verdicts. Carissima Mathen is Vice Dean of Law at the University of Ottawa. She joins me in the studio. Welcome to the show about something people can all understand. This is not a popular verdict.
It is not. I feel like if you try to stay neutral, you have to wear a hazmat suit, basically, to discuss this case. But I shall try. All right.
Well, we don't care if you're neutral or not, just as long as you're informed here. I'm curious. The Constitution talks about, in this beloved Section 121, trade being admitted freely into the provinces. Why doesn't beer qualify?
Well, beer doesn't qualify in this case because it was part of a provincial monopoly to control the consumption of alcohol within New Brunswick, other than through the liquor board. Right. So whether it was coming in from outside the province or, as the court itself said, from garages and bootleggers, the idea was that if it didn't come from the actual liquor commission, that's what made it against the law. So that's how the court dealt with the specific law here.
But are they thinking this all relates to the old colonial days of tariffs and that sort of thing? Is that what they're suggesting, that's not constitutional?
Well, they certainly said that the original intention of Section 121 was to remove these various customs that would have been in place in the individual colonies that came together to create Canada. So the idea was you would remove that power to the federal government. Now, they could have stopped there and they could have said this only applies to tariffs, and that would have been, in a sense, an even narrower ruling. What they said was tariffs and other barriers that impede trade are covered, but you have to show that the law is intended to interfere with trade. What does it say about the court? Were you surprised they took this approach, or did you think this was expected? Well, I have to say that at the hearing, I thought the court seemed pretty skeptical of Mr. Comeau's arguments. I did, and I wouldn't have been shocked to see a decision from the bench. Obviously, they decided to take the time. It was such an important case to issue fuller reasons. I was maybe a little surprised that it was unanimous. I mean, that to me says that the court was really quite confident in its decision. I sort of looked and I saw them use the word incidental. Like, this is an incidental complaint against the Constitution. I'm going, okay, does that mean there's constitutional issues here? It's just that this isn't a big enough deal for us to worry about. No, so this is part of the term of art that we use in division of powers cases, like cases arising under the BNA Act, the old Constitution. Incidental means here that the effects on, let's say, interprovincial trade are not part of the core of the law. So it's not part of what the province was trying to do in setting up, let's say, a liquor monopoly. So the incidental effect can be quite significant in terms of the person who's subject to the law, but that's not enough to make it unconstitutional. So I'm trying to understand, like, if a guy wants to go to Quebec and buy cheaper beer and then bring it over to Ontario, what is the court objecting to in that? Is it they're saying the province is trying to keep out competition, or is the province trying to regulate consumption on this side? What are they arguing here? Well, it would depend on how, in this case, let's say Ontario actually made the argument and what the actual Ontario laws were. What the court said with respect to the New Brunswick law is that it wasn't directed at trade. The court accepted an argument by the provincial government that this was for example, health and safety reasons. And we can think that often we do think of regulating alcohol not just about money, even though it clearly is a huge source of revenue. Right. But the court was satisfied that that wasn't the core purpose of the monopoly and therefore the associated offenses. I'm curious if this goes beyond beer, and we use beer as sort of the catalyst for this verdict, but I mean, and wine. I don't know if it goes tobacco to pot or oil. In the case of Alberta, Alberta is using oil as a trade weapon against BC. Are there ramifications beyond this case that are going to be felt from this? And does this impact that Trans Mountain food between Alberta and BC at all? So I do think that there are deeper implications. One of the interesting things about this decision that not as many people are picking up on is that the court does say that if the province's intention is to impede trade, that is a violation of Section 121. So if you have a province taking targeted action against another province, and it's clear that they are trying to, let's say, punish that province by affecting trade with it, that potentially is vulnerable. Now, and that I think could have an effect in terms of the current dispute.
Right, because Alberta is saying we're going to cut you off, and only you, only BC, not Saskatchewan, not Ontario, not Manitoba. It's targeted, right? It's
targeted, and the court says you look at the evidence, and if you have very open statements about what the purpose is, I mean, you're opening yourself up, I think, to a challenge.
Well, interesting. The Supreme Court doesn't always have relevance to the daily lives of Canadians, but this is one of them. Thanks, Chris. I always appreciate you coming in. Okay, the Canadian Chamber of Commerce weighed in on today's ruling. Here's their statement. They basically said, wherever it is, there it is, today's decision will only reinforce most of the barriers that currently impede trade within Canada, driving up business costs and hurting Canadian consumers. Well, for his reaction, let's bring in Dan Paszkowsski. He is the president of the Canadian Vintners Association. Welcome to the show.
Thank you.
I'm sorry, we have bills passed in Parliament. We've got public opinion surveys that say Canadians want this. We've got studies that show internal trade barriers are bad. Were you surprised by this reaction or this decision?
Well, we were surprised and extremely disappointed by the decision. We thought this was a great opportunity to move the Canadian wine industry into the 21st century. But instead, we've got 700 wineries, 1,500 grape growers, and a lot of farm families that are lost in terms of the opportunity that this could have provided.
Explain to our viewers how this works now and what could have changed for the better if this decision had gone the other way. What are some of the anomalies you've been encountering?
Yeah, well, today you take a look across Canada, and about 10% wine sales market share accrues to 100% Canadian wines. The vast majority of wine sold in Canada is imports. About 75% of total wine sales growth in Canada over the past decade has gone to imports. So what this could have done was provided an opportunity for access and choice to Canadian consumers for BC, Ontario, Nova Scotia, Quebec wines that are not available for sale in a jurisdiction where that consumer lives. The decision today didn't allow that to take place.
So if I'm an American, I can buy in a Canadian wine store and take it across the boundary there, but I'm not allowed to bring it into another province.
Our winemakers find this problem all the time. They'll be at the winery and you'll have two consumers at the till, one buying a case of wine, he's from America, the other one is, say, from Saskatchewan. We can ship the wine to the United States, but we have to tell the consumer from Saskatchewan it's illegal to do that.
Is this all about protecting monopoly pricing? Is that what this is all about?
Well, in part. I mean, we do have a liquor board system in Canada, but you know, in 8 of 10 provinces, there's a less than 5% wine sales market share as a 100% Canadian wine, which tells you that our wines are not readily available in liquor boards across the country. So what we're talking about here is providing Canadians with access to wines that are not for sale at the liquor boards in the provinces. The research that we found in Alberta, in British Columbia, and in Ontario is if a tourist visits a winery, chances are when they go back home, they're going to buy more Canadian wine. They're going to buy more wine in general because they're more educated. So we see this as an opportunity to augment liquor board sales, not decrease liquor board sales. It would be a win-win-win for everybody.
Yeah, I mean, it's silly. Right across the river here in Quebec, wines are cheaper, beer is cheaper, yet, you know, they can't bring it over here, even though I think there's an awful lot of traffic going back and forth. Anyway, is there an option that this will change? Is there a possibility this is just a setback, not a final ruling?
Well, as disappointed as we are by the Supreme Court ruling, which would have engaged every province to take immediate action or action over a set period of time, that didn't happen. But we do have a Canada Free Trade Agreement. There has been a process established, a working group, a federal provincial working group, to take a look at barriers to trade in alcohol. That group has to report by July the 1st. We have made presentations to that group. We have answered questions of that group. We've developed a really good relationship. And we're hopeful that what we have proposed for a legislated winery-to-consumer delivery system in Canada will be recommended when they put forward their report to internal trade ministers in July.
There's hope. All right. Thank you, Dan. Appreciate you coming on.
Thank you.